Good afternoon, everyone. My name is Giacomo Delledonne. I'm an assistant professor of constitutional law at Scuola Superiore Sant'Anna in Pisa, and I'm one of the editors of Sant'Anna Legal Studies, STALS, together with Professor Giuseppe Martinico and Filippo Fontanelli. This webinar today is part of our webinar series in which we present and discuss and collect thoughts about recent books. Today we are going to speak about this recent monograph by Matteo Nicolini, Legal Geography, Comparative Law and the Production of Space, published by Springer within the book series Ius Gentium, Comparative Perspectives on Law and Justice. Matteo Nicolini, the author, is Associate Professor of Comparative Public Law at the University of Verona. He's an eclectic scholar with wide scientific and cultural interests in comparative public law, constitutional law, law and literature, law and agriculture. He has written extensively on a number of quite diverse topics, including bicameralism. And in the last few years, he has devoted many of his efforts to law and the space, law and geography, legal geography. And this book is possibly the most important accomplishment in this strand of Matteo's research. We have one discussant this afternoon, so there's a difference with respect to the program. Professor Cristina Poncibò, Associate Professor of Comparative Public Private Law at the University of Turin, and author of a book on Geografia Giuridica. So, Matteo, the floor is yours.
Can you hear me?
There's some
Can you hear
echo.
me?
There is some echo, Matteo.
Yes.
Yeah.
Can you hear me?
Yeah, I can hear you, but I think you cannot hear me.
Just a moment, because it is a big problem here. Okay, can you hear me now?
Yeah, but there's an echo.
Yes. Okay. Thanks, Giacomo. Thanks for the organizing the book launch, and thanks to Giuseppe, who is also here, and thanks to Cristina for accepting to discuss with us this book of mine. And thanks for Cristina, because Cristina is one of the few legal scholars in Italy who also shares this interest in law and geography. We are indeed now finalizing a special issue of comparative law and legal geography for legalities, that is an Australian and New Zealander law and society review that is going to be published in at least by the end of the year or the beginning of 2024. So I think thanks for accepting, because you are probably one of the most credited scholars that really can, with whom I have already been discussing for a long time on this topic. And she also hosted 2 years ago now a conference in Turin on geographies of space, and so thanks for accepting our invitation. The idea of this presentation is probably related to the fact that legal geography is one of the stream of cross-disciplinary research that is being particularly explored in the Anglo sphere. I'm not the first one that in writing this book, but I think that this book, from my opinion, can really contribute to this new field of research. the idea of, I will try to explain you why I have come to write a book on law and geography. The first one is that I'm a legal scholar, and as all legal scholars, we should be interested in the space and the place that is fall under the regulation of legal rules and provisions. What I understand is that the idea of coming back to place and space is one, I think, of the commitments that a lawyer should have. We live, not only do we live in spaces and places, and with a subtle distinction between both lexical items, but we also, as legal scholars, apply, and also practitioners, apply the law within space. So most times, quite often, the law is a situated legal practice. That is to say that it is part of the environment we live within. And it is my opinion that several legal scholars have now more focus on the legal technicalities and subtleties than on the space that fall under legal regulation. So one of the main, one of the purposes of the book is to come to put space back into the fore of legal research. It is a kind of methodological approach that also accounts for a kind of, I think, a legal autism that several scholars, in my opinion, do practice. So the first one is that lawyers need space, and space needs lawyers. And this is the first statement that I can do as regards the rationale that underpins the book. The second is that space is a place where law and other disciplines intertwine. Most of the time, we find geographers that are there exploring the field and dealing with the problem related to space and place. And there is indeed a fruitful and wide group of researchers, and both lawyers and geographers, that fall under the banner of law and geography. But and this is the second main statement, and rationally underpinning the book, is that a fruitful encounter, that is to say, something that a more critical and a more cross-disciplinary engagement with geography, at least from the perspective of the angle of lawyers, is that to try to boost the cross-disciplinary ambitions of our field of research. And to this extent, examining geography from it is important. But the idea was to try to focus on the special relationship between law and geography, trying to turn it into what, as Cristina, I, and other colleagues terms as legal geography. The idea is that to try to make the disciplinary boundaries fast. This is particularly apparent in one of the most traditional ambits, legal ambits, which is to say, the study of states and the state law. State is indeed a cross-disciplinary construction that lies at the crossroads between law, geography, political science, sociology, and I think it is a fruitful place where we can start. But it is not the only one, not the most relevant. The most relevant one is indeed, and here we jump to comparative law, and in its close relationship with geography. Another assumption that underpins the book is that we, as comparative lawyer, have a say on the establishment and of the discipline. Comparative law indeed helps us to ascertain how the law is not only a performative force in geographical terms, but the law is also a spatial practice, and it's probably one of the variables that is able to rewrite how space functions, how faith operates, and how communities activate the special dimension of legal rules. So it is by boasting the cross-disciplinary ambition of comparative law that I bumped into the special relationship between law and geography. Why is comparative law so well equipped? Because comparative law, like geography, has an intellectual ambition. It tries to grasp the world intellectually. Secondly, because its methodology is, at least on paper, empirical. That is to say, it is more interested in a kind of bottom-up approach than to a top-down application of legal rules. And it is also able to, to join history, sociology, and economics in order to ascertain how this space is saturated with things and variables. So I assume that comparative law can really disclose the deep connection between the law and the context within which it operates. So this is a kind of trying to come back to the law as an unfettered practice. This is probably my biggest ambition when I try to do this. And whilst writing the book, I also bumped into in one of the most important and renowned strands of research that related to geography. It's a post-structuralism and a cultural term in geographical studies. I'm neither a structuralist nor a post-structuralist. I am a lawyer, a comparative lawyer, which is keenly interested in engaging in a dialogue with different and other disciplines. But I assume that the idea that Henri Lefebvre in the 70s and then Ivar Soja in between the 80s and 90s defined as the production of space is particularly suited when it comes to ascertaining how comparative law may really contribute to this new field of research. And I come back to the beginning of my presentation, that is to say, the idea of law as a variable that is able to set the situated legal practice where we operate as lawyers and also the geography. And coming to the book, this paradigm is particularly apparent in how I decided to arrange it, to digest the different the problems. So the idea is probably that the production of space is intriguing for is probably the most interesting perspective, because the idea of producing space can add also to boost our methodological devices, and it is to say, more important, the traditional division between law in books and law in action, between the flows, between the rule written in the constitutions and in the black letter law, and then the operational rules that were applicable in the production of space. No wonder, therefore, that one of the main examples I usually quote within the book is that of Cyprus. I have extensively studied it. I also had a fantastic conversation with Andrea Stefano professor at the University of Nicosia, and I also wrote some essays, and there, with mismatch between law, territory, space, constitutional arrangements, and the way communities reframe and reimagine societies appear to me particularly intriguing. So if we have to also to find besides the methodological approach, the starting point was the study of the Cyprus state, and this is then coming back to space. The biggest problem was also to try to understand the fix that has been also populating geography. That is to say, when we try to turn law and geography into legal geography, we have also to try to understand why geographers are strongly divided upon disciplinary terms. I also read several articles on the fissure, the juncture between human geography and physical geography. As it were possible to examine the space-place environmental nexus, that is to say, the place we live, we regulate, and within which we are also shaped as something that would be completely disentangled. Well, this is the idea of merging human geography and physical geography has also been defined by Johnston, a kind of disciplinary environmental fix. So not only did I have to, when writing, I had to try to to merge law and geography, but I also have to try to make my mind as regards as the fissure that is the juncture that is inherent to this geographical field. What saved me and what was particularly interesting was also the use of philosophical patterns in examining what the law is in space. One is the idea of the disciplinary, I call it disciplinary metric, that is to say, the idea of Kuhn's paradigm shift. And the second was Ludwig Wittgenstein, which provided me, when reading the Tractatus Logico Philosophicus, the idea of the logical space. Well, there is something that lawyers usually underestimate when examining the relation between law and geography. The fact that what we see out there, whether they may be communities, mountains, watersheds, or, I don't know, ice in the Antarctica, they are usually products of a clear narrative. A narrative that several agents within which have a political, legal role in shaping the earth and in writing the word apply. That is to say, the idea that we are humans, and as humans, we have a kind of radical attachment to places. We want them, we want to get all of them, and this is particularly apparent, I explain it in the book, when I use the word erreichen, the German verb erreichen, to get all of the idea of trying really to physically apprehend the world. So we want to get, it is something that is inherent, radical in the humankind. Not only because do we want to get physically control the world, but that what is meaningful to us. It must be meaningful. We attach meanings. We try, and the law, the narrative of the law, assigns a meaning to that place, and in so doing, spaces become places, and therefore meaningful. This is the projecting of the logical space. When we are able, this is my opinion, when we are able to normalize the meaning we assume is the interface between human geography and physical geography, a meaning that we usually convey through the law, when we are able to normalize analyze the idea we have of a given logical space, well, we have probably rewritten the word. And yes, it is a contingent process that we know as scholars, humans try to make permanent through the law. And I then tried to apply these mechanism of interpretation of the production of space in legal terms in several environments. The first one was physical geography, where I understand that I also term it the law of spatiality. We reproduce, the word is there. It's not a problem of, I say, of ontology. It's a problem of interpretation. It's not a problem of existence, but of the meaning we attach to the word. And when the law outlines spatiality, we have probably rewritten it and create new spaces. The second mechanism paradigm I use is that of spatiality, a kind of rereading of that area of comparative legal studies that falls under the umbrella of legal systems of the world. How we are able to reprocess the world and its physical human features through the law, trying to, to depict and to represent the world as Leibniz wrote theatrically. Another example is probably closer to another pattern of production of space I examined, is that is probably closer to what legal geographers usually examine, which is to say, the critical legal geographer. The idea that within a situated legal practice, there is a constant conflict between two different ideological spaces. We know that there are two agents, two imaging geographies, two interfaces trying to get hold on a given space, trying to make it become a place. One of the case of the native title doctrine, we have a superimposition of Western devices onto pre-European communities, and the law is the variable that try to, to rearrange them and according to one of the two imaging geographies. The second is the idea of the spaces of globalization, where we have probably the biggest conflict between the capital, financial capital, and the oldest of global capital, and the necessity of rewriting the rules of these spaces of globalization, and then the idea of the spaces of dark and terror, that is to say, where the space of nowhere, where terrorism and counter-terrorism interact, trying to assign a meaning to the disaster they've been making for a long time. And then there is also the problem of migration, immigration, and so called the idea of the world ideological spaces. And then in the second part, or the last part of the book, I try to apply these patterns, this way of producing space, to federalism, to try to give a different insight on how federal features are written, are created, using the labels from legal geographical primitives, trying to apply geographical instruments into the field of the law, and trying to explain how in this process of spatial production, territory, communities, and this process of getting hold of space is usually more important than the mere distribution of competencies between national level and constituent units. And then the last part is devoted to some neglected spaces. That is to say, spaces that on the surface seems to represent a place of unbounded communities, deterritorialized. The idea, for instance, of the atmosphere that we really populate and get on hold through by polluting it, the global regimes connected to acquisitiveness and waste. In this sense, they are not probably territorial physical space. They are probably territorial in the sense we assign them a territorial meaning when creating divides between affluent communities and poor communities. And then I try to reread the space of the Anthropocene. The Anthropocene as a kind of place where probably we have the illusion that we can go beyond borders, beyond communities. It is the core construction, production of the humankind, the anthropos, which is also able to it's a kind of eulogy of the humankind as a sole individual able to produce new spaces, the digital spaces, and also the spaces of the climate change. And to this extent, I can only try to recollect, to gather some concluding remarks on my introduction to this book launch, trying to say, yes, that is, legal geography is really a way of grasping the world intellectually and scientifically. I don't know if it had already acquired the status of a legal discipline, but I think that as comparative law and geography in their respective fields were able to elaborate, to shape their own methodologies, and then to reflect on how these methodologies must be applied in order to gain the meaning, the profound meaning of the word. Right? This way of reflecting transformed, converted both comparative law and geography in disciplines on their own. So I think that we can try to be brave and innovative. I know that if we examine these ambits by sticking to our disciplinary boundaries, we are not doing the right thing, at least because if we assume that there is only a perspective when grasping the world scientifically and intellectually, well, we have to understand that we are merely picking up arguments, discarding those arguments that we don't like, without dismissing our role as lawyers and comparative lawyers. We have also to try to understand how the other also grasp the world scientifically and intellectually. And because and this is my last assumption, we must be, how to say, at least disciplined in practicing this kind of new evidence. That is to say, we have to follow our scientific methods and then try to understand it according to our dispositions and abilities. And I think that as lawyers, and in particular as comparative lawyers, we still have the ability of having a look at the world out there, coming back to what defines us as an epistemic community. That is to say, those that have constantly been able to regulate and understand the world in order to avoid the collapse of our political communities. Thanks.
Thanks indeed, Matteo, for this insightful presentation. You have helped us form an idea of your roadmap, your goals in this intellectual journey. Now it's the turn for our discussant, Cristina Poncibò. So you have the floor, and thanks indeed for being with us today.
Thank you to you, Giacomo, for your kind invitation. I hope you can hear me correctly. It's a great pleasure to me to be the discussant of the book of Professor Matteo Nicolini. And probably I would use the same words Matteo is just pronounced. This is the book that shows the skills and the qualities of the author in the sense that you need to have really an eclectic researcher, someone able to manage a number of different research questions and fields to tackle the different issues discussed in the book. That I think you'll agree with me is absolutely rich of ideas, no? Rich of suggestions, and is really food for thought. That is, I think, the goal of each of us when we try to write something. Almost the large majority of times we try to say something that is stimulating the debate and can give perspectives and ideas to colleagues or fellows or juniors or to contribute in some way. And apart from eclectic, I would like also to use the same words, brave and innovative, in the sense that you should be brave to decide to write a book like this, because it's dealing with across disciplines, and you have to manage a number of perspectives at the same time. It's new, it's a challenge, and you know that you take a risk when you do something like this. So I think we have to be very grateful to Matteo for being so brave, no, and so eclectic. That is a quality that I think you can agree with me. It's so important for a lawyer and a researcher and academic in law, but it's so difficult because of the way we have been trained. No? I've been trained in a very classical way some years ago in Torino, that, you know, is the place where you can really have stimulating classes in comparative law for sure, but the curricula apart certain areas like comparative law, and that's why I jumped into comparative law at the end. No, I decided to try to do research in this area that was so stimulating. The overall curriculum was definitely totally disciplinary and based on positive law for large part, with some exceptions like comparative law at that time. And it's still so in part. We are changing, no? Don't you think so? We are changing. So many new way of teaching the law, so many possible new understanding of the relationship with other disciplines. So I think for this reason, this is a very important contribution. I have a few points I would like to raise as discussant in 10 minutes, 10 to 15 minutes. Please let me know that I'll be on time. A few issues, a few points, and a sort of forward and a final question to Matteo about open issues, critical issues for future research in this area. So Matteo has mentioned the issue of digitalization and deterritorialization of law. And this is precisely the area I came to, legal geography. I was writing on things, you know, completely far from the theory of law, very practical issues like, you know, blockchain and digitalization and in comparative perspective and regulation so far. And I was asking myself about the link between comparative law and deterritorialization. And I was thinking geography has been first to be able to detach from territory, because you can have the classical geography of places, but you have geographies that now are, as geographers and friends told us, completely detached from any kind of territory and goes to individual perception, social geography, a variety of ways of understanding geography as a discipline in context detached from territory. And I had a question. I asked myself a question. How far has comparative law been able to detach from territory, to explore deterritorialization that indeed is in front of us every day in our lives? And my answer has been, I'm not completely sure that we have been so good as geographers to understand this dimension that are not linked to territory and to positivism at the end, state law, or, you know, supranational law, but always thinking in the traditional way of the division across territories. So starting from this question, that is a research question that is open for us to discussion, I started doing some research and I came across the writings of legal geographers. That's why I'm also interested in this area. As Matteo has mentioned, we met at the workshop we have organized a couple of years ago, tried to engage geographers from everywhere, legal geographers. It has been really interdisciplinary in the sense you had contributions from a number of angles and perspectives. What we can learn from legal geography as comparative lawyers. And this is the book of Matteo. This is what Matteo has been able to achieve in this book, to create a comprehensive framework, and this is the first one, about this relationship, what we can learn and which are the mutual benefits of such a dialogue. And the first point is the fact that legal geography is really cross-disciplinary. When we had with Matteo the possibility to talk with people in the field, the leading legal geographers, they were totally convinced about the fact that this area of investigation has been developed without thinking in disciplinary terms. So they address the problems, the issues, the realities from a number of angles without a clear disciplinary boundary. Wow, I was thinking, it's so interesting, this shift to cross-disciplinarity. But at the same time, and I anticipate here a possible open question for Matteo and for participants, it is not so easy. Because when we discussed with this point, we were, you know, particularly happy to know of this aim of legal geography with people in the field. They were saying, yes, but we don't know. Maybe we're going to establish a discipline, maybe not. We went to this Law and Society global conference and we were thinking to have our session, but maybe not, because maybe we need to be more disciplinary to get a better understanding of our epistemology, our methodology. So maybe we have to build up a discipline with boundaries. But at the same time, and this is an open question now, there is no answer to date. I think people like Blomley and others, they are trying to do this effort now to decide where to go. And in one direction, in many as far as they've been able to develop as a discipline, probably we will lose this innovative force. How much we can practice cross-disciplinarity in the academia as academia is today, especially in law. Second point, I'll try to be shorter, but you know, it's really stimulating as a reading, this book. So basically, the point about the territory and one one part and one chapter of the book is precisely about how much we can develop our investigation without grounding on categories that basically are traditional. I'm teaching comparative law and introduction to. And when I'm teaching, I go back to the legal families. I need to explain this to my students of the first year, second year, and I know old concepts sometimes. You can kill me, but I still think that for training reasons, it has sense. But in research, I think we have to move further and further. We have spaces that we can investigate that are completely detached. And I try to do so in exploring, for example, digital communities and the way they rule themselves and how you can think to a legal format in such digital communities and comparing solutions from one digital community to the other. And this is just an example of the possibilities when we detach from the link with territory. Another point that is important of this book is the part on colonialism. And as you know, one of the leading comparative lawyer in this field is today is carrying on a project about the theory of decolonization and comparative law, in the sense that he claims with colleagues that, I mean, this is a path that we have entered into, but we are still in that path. And in comparative law, much remains to be said with the link with colonialism, or the link with colonialism, how much our concepts are still vested after years, after discussions of this sort of way of thinking that is based on a colonial, totally unacceptable today idea. And then other points that this book is provocative. It gives, can we borrow concepts or exchange concepts in between our areas of research? For example, I personally find fascinating the idea of discussing of social spaces or no places, or there are plenty indeed of ideas. Space in an abstract sense, or the individual perception of space. As you know, the concept of no place is interesting. When you say you have a place where there is no law, Guantanamo was a place with no law, basically. No respect of certain rules of the law, because it was a unique place. Why a unique place? Because of the political and historical, needs of the time of one power in our global society. So basically, borrowing of concepts, not only of concepts, there is a part of the book that is entirely devoted to methods. And exactly, we can discuss of the possibility of learning in methodologies. Comparative law is often field work, but for example, ideas such as the space talks and other similar ideas from legal geography may deserve our attention, may be discussed further and further. And another point that is discussed in the book is how much is important to be able to localize legal transplants. To a certain extent, these are goals that comparative lawyers have been able to reach already. A lot of acquisition, but indeed putting new lenses to look at old problems, how we can localize more the phase where after the transplant and the context, so you can have many factors that are based on social spaces or legal geography concepts. And then there is an important point at the end of my discussion, and I think is essential. I ask you a provocative question. Are you really happy with the state of comparative law research? This is really provocative, in the sense that we have had a number of critical researchers and critical approaches have been discussed. But over time, we have, it seems to me, lost some of our critical and innovative force. I think comparative law, it has been said already, has a disruptive force in itself. That's why we love it, because we have been able to go beyond other disciplines in law, in addressing society needs, in connecting with other areas, in being innovators in law, in the way you teach law, in the way you think to the law. Where is the critical perspective? In legal geography, there is a very, very active, especially after COVID-19, especially in these contested times, very strong aim in critical approaches to geography and law, that we can get some inspiration or we can establish some dialogue with them. They are very strong, they are very active. And finally, to conclude, critical issues. I've indeed underlined the most critical. Legal geography is, an ongoing project in itself. And how we can learn if they do not establish themselves, if they've not been able to define themselves. I'm quite a traditional lawyer. Sometimes I need some sort of clarity, and clarity in the wording, clarity in the definition, clarity in epistemology and method. Legal geography has a great complexity. And what is great is that Matteo is able to manage this complexity, is not afraid of. And obviously, a very final point, how much can we go in cross-disciplinarity when we still teach the law in a very disciplinary way in most cases? And so my question to our author is about the future, in the sense how you see the possible developments in this area and how much we can go in linking comparative law to interdisciplinarity. In this case, I think obviously to the book of Jaco Husa. I think interdisciplinarity is often mentioned by us, but rarely really practiced. And this book can be a first step in this direction. So thank you for giving me this space to share with you my thoughts, and I'm very grateful to all of you and Matteo for this opportunity. Thank you so much.
Thanks indeed for your remarks. Matteo will have later some time to reply. Now I would like to open the discussion. So if you are interested in asking questions, raising comments, you can raise your hand. There's a button in the WebEx platform, or write it down in the chat. I have a small comment for Matteo, something that is related to the fact that I'm someone who does constitutional law and comparative law, and I think that reading your book is helpful in revealing some flaws, some interrupted paths in our way of thinking. We are confronted, I think, to a real paradox. The space, or better said, the territory, is one of our usual notions, of our key notions. It's one of the components of the state, but still, in my view, it's a relatively under-theorized notion, at least if you compare it with the people. And the same is true if you have a look at positive law, at constitutional provisions. So they mostly make reference to the territory, but don't define what the territory is. And I agree with you that here the Cartesian frame is fully at work. So the idea that the space is ultimately a place where norms are recognized as valid. But there must be, I think, something more. I think of, perhaps it's a bit an elephant in the room, Carl Schmitt's writings on Roman Catholicism and political form. So Schmitt argues Catholics have a different relation to the soil than Protestants, perhaps because they are mostly agricultural peoples who know no large industry. Catholics never lose the longing for their homeland, unlike the Puritans, the Huguenots, and so on. And if you think of his way of conceiving of the relation between theology, political theology, and legal concept, I think these remarks about the relations of Catholics and Protestants with the soil, with territory, are quite revealing. So what are your thoughts about how to unlock these knots? Thank you. Giuseppe Martinico.
Thanks indeed, Giacomo. Please let me start by thanking both Matteo and Cristina for this very fascinating debate. I've learned a lot. I think that this book is a gem. I had the privilege to read the manuscript, and I tried to contribute with some very minor, comments. So I'm very happy that this exchange has produced such a fantastic and brilliant and groundbreaking research. And I want to build upon what Giacomo just said, invoking or evoking the ghost of Kashmir, who is indeed, the elephant in the room. Kashmir has been very influential in a field which is, of course, different from legal geography, but which is also somehow, related to it. And of course, I'm referring to geopolitics. Kashmir has been very influential, especially in the paradoxically in the debate in the US. So my question for Matteo, also in order to explore, in order to make clear the fundamental added value that this book can give to our field is how does this book help us overcome the Schmittian legacy in this area? Because as I really share the criticism that, for instance, Hannah Arendt had in some notes that have been more recently rediscovered by scholars, in which she criticized a lot the nomads of the earth. Thinking that Kashmir, understanding of the space was really rooted, on the idea of violence, of course. So, and thinking that his approach to the territory was, to a certain extent, the sort of imperialistic, approach. Now, I'm not in a position to, say if whether Hannah Arendt was right or not, but I think that legal geography can help us for sure, rationalizing how the law applies to the territory, going beyond, for instance, the concept of conquest that was so important in Kashmir, understanding of the phenomenon. So, but I wanna would like to ask, you to elaborate on that, and to explain, why it is so crucial, to embrace legal geography in order to, again, go beyond Kashmir. And the second question I have is, again, how does legal geography help us in order to interpret and in order to overcome constitutional problems related to phenomena that are in part, at least, also territorial? for instance, secession. It is another beast that I think it is up to constitutionalism to domesticate by trying to govern it, relying on norms, without, falling in the temptation to, accept a posteriori the use of violence. And in this sense, that I think that this contribution can have an important role in providing constitutional law scholars or comparative law scholars in general. Going beyond the private law public law divide. Can help us, of course, in providing, lawyers with the tools and instruments and categories that can improve our function. Thanks so much.
Thank you, Giuseppe. Any other remarks? Otherwise, since we have collected a number of points, above all from Cristina, I think that it's Matteo's turn for replying, and possibly later we will have another round of questions. Matteo.
Okay, thanks to Cristina, and also thanks to Giuseppe, because I didn't expect that Cristina, particularly Giuseppe, we have been discussing the topic for a long time, because he was the only one I asked to read the manuscript while I was writing it. Cristina, thanks, because your words are extremely too kind for my book, but thanks. You know that you are the critical issues you've just posed. They don't have a linear solution. They have a critical geographic solution, if you want to say, because the first thing is that, yes, we come from a traditional classical curriculum, and we also have to experiment with new way of teaching. We are probably one of the most, how to say, we are the class of scholars that are probably master not very at ease with this period, because we are bridging a past. We were trained in a period completely different, extremely formalistic and disciplinary, and we have in front of us a new group of young people and students that ask us to try to solve and to find new and alternative readings of the world. So this is a big problem, because we live in this state of limbo between the past and the future. And yes, I don't know if we have to dismiss the past. I think that we have to teach the foundations of what we do and try to be, we can also learn from our students. We can try to do some experiments, that is to say, to move beyond, in our case, traditional comparative law, trying to put ourselves in their shoes, trying to take some laboratories, trying to put them, to ask them to shed a new light on what we do. For instance, there are lots of my students that are connected today. What I ask them is to also to study a classical topic or something, and then to digest it, and then come back to me, present what they think. So I think that we have also making cross-disciplinary comparative law doesn't only mean to dismiss, to discard everything we did. It's also trying to understand there are alternative avenues and perspectives, and try to understand that the recipients of our teaching is probably the first way we have to try to do a more cross-disciplinary comparative law. And then what you say about the digital and comparative law, it is incredible, because I agree with you to the extent that we we create something that is detached from territory. But the research question is that we also localize it. What makes the difference, in my opinion, is the fact that we don't really, and we are not really unhappy with the current state of comparative law research, as you put it, because thinking critically is really trying to understand what the word means to us. When I discussed Jacomo's book, it was invited to discuss, I didn't tell the audience that we have to stop being disciplinary in our training. We have to boost the potential that our being comparative lawyer in this case help us. The law is, in my opinion, inherently cross-disciplinary because we regulate the world. When as comparative lawyers, we want to understand how the Constitution is written that way, but then when it comes to applying it, the system is completely turned upside down. This is probably the understanding how the world interacts with us. And this is also what geographers do. The case of squatterism and informal settlements, for instance, a place where you really, when you talk, and you're right, it is cross-disciplinary because in some cases, they know about the law and how the law works there in these settlements more than lawyers do. So we have to reframe our way of seeing cross-disciplinary. This is my opinion. We don't have to dismiss ourselves. We have to understand that the word is not written on paper and in the closure, on the bracketing of the law. So yes, I'm very unhappy because research must be to disclose this, to try to introduce disturbing arguments in order to stir the situation. But I think this is also the meaning of doing research. As for Giacomo, well, you are right when you say that territory is under-theorized in law. A few months ago, Nicholas Blomley, one of the forerunners of critical legal geography, published a book on territory and in the law. But we are not able to appropriate it and to reconceptualize it in legal terms. We are still dependent upon what other disciplines say about territory. What I try to do is to demonstrate that there is the political legal and legal interface that is able to explain that territory is not only an ontology or something existing there, and that lawyers must consider without trying to theorize it. It is also the outcome of the legal interface between human and physical geography. Probably this is probably a new, try to say something new as regard to territory in legal study. I think that then when you say about Carl Schmitt and what also Giuseppe says is a case in point. I'm not particularly dependent upon Carl Schmitt. It's something that I discussed with Giuseppe. I'm dependent of a legal historian that used the item legal geography 100 years before the birth of legal geographical studies. It is Frederick William Maitland, a great one of the founders of English legal history. He was mapping or trying to understand, lectures on the legal human geography of Cambridgeshire. So a case study where we really use this word. And I think that Frederick William Maitland, and also that's the stream of, non-continental way of understanding the world along global lines, Carl Schmitt essentially did, is also intriguing, because what I also use Carl Schmitt when trying to understand how the world was mapped in the aftermath of the age of discovery. But there is something that, what you say about Carl Schmitt is right. A kind of holistic approach coming probably from this Roman Catholic background. The idea of a kind of whole world that was grasped under the idea of a kind of theorization that the world is both visible and invisible, and the way it is interpreted, kind of the meaning of theological, legal, the essence and the ontology and interpretation, what is visible and what is invisible in terms of the world, are the same thing. They completely overlap in Carl Schmitt. It is something that is completely different in the Anglo sphere, where the first thing is that there is probably the fragmentation coming from the Reformation period, means that we have also to come to terms with contingencies, something that comes from the legal theory jurisprudence in English, but the word is there. You can try to grasp it scientifically and intellectually, but you know that the world is also full of disturbing arguments, and it's difficult to grasp it. You have also to understand that while grasping it, you can also, stumble. So a more subtle and less, invasion between attentiveness to these things. So what is visible is also not always is visible what is invisible. They can be separated. And the second thing, this is apparent in how I treat the relation between the landmass and the water, the oceans. Carl Schmitt didn't pay attention to the sea, to the oceans. The English did it, certainly, because they understood that kind of unbounded place. Schmitt termed it as a kind of a place without character. It's useless trying to map it, to assign a meaning to it, because when the ship passes over the ocean, then the line that has been drawn systematically disappears. So the sea is a place where you can't really find a meaning. It is not so for the English. And it wasn't, and likewise, it wasn't so for the Portuguese, where, and this is apparent in how you can change the words and produce space. The case is that I shifted from conquest to discovery. Discovery is something that you find and that you also produce. When you find something new and you don't know what it is, you assign a new meaning, you made it meaningful to you. You don't pay attention, and then you try to normalize that meaning. It is the problem of also overlappings, imagined communities and geographies over the world. So I think this is paying attentiveness to contingencies and trying to understand that what is out there might be different from what you assume is meaningful to you. It's more important than to try to reconcile interpretation and ontology in the world. And we have to understand if you want to elude Schmitt's argument. And then, yes, there is, as regards to the idea of secession, I tried to frame this concept of territorial constitution. It is, when I talk about federal features, I don't start by quoting how competencies are distributed and listed. I start from the demarcation of territory. The idea of a territory is assigned a new meaning, the meaning is contingent, and the law, particularly constitutional law, try to make it, how to say, absolute. We know as lawyers that it is a great fiction that when we constantly change the meaning we assign to territories and places. But we know that how we frame in the law, usually in open textures, well, this helps us to accommodate the way we probably deliberately change the meaning and the space we create. And we change it, we deliberately make them accommodate. So this is, and well, territorial constitution, I call it a kind of legal geographic primitive, an instrument whereby you can try to, primitive is a term that I borrow from GSI, geographic, from the way that the way that digital geography is used, geographical information. And the idea is that when you have a variety of meaningful places there, well, the territorial constitution give you that ability of, how to say, accommodating a variety of subnational meaningful spaces. And the territorial constitution provides us with that flexibility in order to accommodate them. Well, we know that the territorial constitution is flexible because it gets all together diversity and get hold of territories. Well, in some cases, it is probably is not able to encompass it, but in terms of getting hold of territories is probably the most well suited in order to accommodate. The idea is that you are not denying the way different communities create it. And this is particularly apparent also in the case of transborder cooperation. I didn't examine it in that because it's different, but what I did is to assume that also these places where of territorial cooperation are also spaces produced by legal practices. What is characterizing of, and their geographers are 7 steps beyond lawyers. What make this kind of functional mechanism functioning, I want to quote Thomas Perrin, a great friend of mine, is the idea that when you create this legal texture, able to, how to say, territorialize functional criteria, in this one, the biggest example of territorial cooperation is how to functionalize human, physical, and cultural geographical attributes. Well, the idea is that you are able, against is an application of the territorial constitution, to create a kind of sense of commonness. Yes, you say, Giuseppe, you can object that I'm talking about philosophy and platitudes, but the commonness is something that helps you to reassign and to reappraise the meaning you project onto the Earth's surface. And it is even part of this interface that the law is able to provide us with.
Thank you, Matteo. Are there any other questions from the audience? I don't know if Cristina wishes to add anything.
I can say many other things, but I would like to leave space for comments, if any, in case there are comments. I understand, I mean, the reply and views of Matteo about my concerns. We can, we can exchange ideas and dialogue with legal geographers, and so it's just one way of proceeding. It's not necessarily that we have to follow the path. So we have some distance as lawyers. No, we have the tools, we have the method in order to digest what is useful and to avoid just to get confused. So I see the point of Matteo about this specific issue that I have raised. In the discussion before, I had no time to address the point about globalization. It's an area where legal geography did a great contribution, provided a great contribution about deglobalization, the fact that you have to put different lenses today. Many things happen, not only the COVID-19, and basically from the innovative perspectives about this specific point on the local and non-local dimension of the laws, and in putting comparative lawyers terms, the micro, the macro comparison, the dimensions, the levels of comparison of institutions and laws. So in legal geography, there is a rich number of contributions. They basically, I used to be quite surprised by the kind of areas they cover. During the workshop we had 2 years ago, we had about 40 presentations, 40, and we have to limit, also because we were coming out from a very difficult period of crisis because of COVID-19. But in these 40 presentations, we have been able to develop 10 sessions, and they were covering geographers and colleagues so many dimensions, no? From the more abstract, I would say, the more based on perceptions of reality and spaces, to specific spaces. In some cases, I was really curious to hear about there were presentations about how we perceive objects and how objects are perceived by lawyers and ruled by law. You have to think to this kind of arguments that are mostly theory of law, but applied to IoTs, the objects we have today, the kind of assets and objects we face today in addressing problems linked to the protection of owners and controllers and so far. So it was so rich. My only doubt was the fact that it seemed to me that there were no clear boundaries, no? That researchers were going in all directions, possible directions. But the fact is that as far as you go and you take so many directions, you risk not to have some sort of coherence in your area. But the perspectives on deglobalization were very fruitful in discussing where we are today, where it seems that we are today, in a world that is completely refocusing on the local. We could say so. This is again an open question for participants, and in addressing the various dimensions, from the rules of cemeteries to the rules of the space, the high space, the atmosphere. Legal geographers are investigating, but from cemeteries, the real concrete thing, unexplored thing, or explored, but usually in administrative law only, to outer space, and local, very local dimensions for space and law. So how to manage these, forces that are going in all possible directions of knowledge? And this is, I think, a good question for the author and for people taking part to our meeting this evening.
Thanks indeed. So I don't see any raised hands. Well, it's
May I say something? May I say something?
Giuseppe. Go
Yeah,
ahead.
just a small thing about this debate on interdisciplinarity. It reminds me of a similar, though different, debate had again in the United States. I remember a very nice piece by Bolkin on interdisciplinarity as colonization, and in which the author expresses some concerns. Of course, it was focusing on law and economics, and the risk of, let's say, in a way, depriving legal categories of their autonomy. I don't think we run this risk, in this area. That's why I do believe that this kind of research is very useful to create new bridges that can indeed enrich, as said, the toolbox of lawyers. But I would like to know, and this is a question for both Matteo and Cristina, if you see, if you see some differences between the American and the European legal context when dealing with the concerns about interdisciplinarity, especially the concerns expressed by old-fashioned lawyers. Of course, Bolkin is not an old-fashioned lawyer. I'm not saying that, but I think that many of his writer concerns that could be used by some old-fashioned lawyers in Europe. So how can we let's say, debunk the possible counter-arguments against this important and useful wave of interdisciplinarity? That's an open question for you. Thank you again.
Wish to.
I understand. The problem is that I agree with Cristina, because when reviewing and reading one of the essays we had for our issue, special issue, we had, for instance, an article on actants. This was written by lawyers and geographers. Actants are entities, humans, non-humans, livable and non-livable things that may have some bearing on how the law is applied. So, I think that I'm not endorsing the idea of actants and the legal entities, but when you talk about globalization and finance and law, the center of the regulation has moved from humans to, to remainder. It looks like something that is typical of the common law. We are more interested in regulating what will circulate, notwithstanding the human that in that very moment is controlling the flux of capital. That is to say, and I think that as lawyers, we don't have, as we also focus on traditionally we do it, understanding that there are also other variables that may help to understand how is it possible to shift from the interest of humans, from humans to non-humans at the corners of legal regulation rules is intriguing, I think. At least I'm not advocating for a change in the law, but for a change in how we can understand how it's possible. Well, it's possible because the world out there has already moved beyond the idea of the man as the only actant in the world. And this is one of the most the most intriguing thing. And this comes from non-continental, non-European dimension. I assume that the Europeans, also English, are probably more traditional in this approach. The Americans are probably less formalistic, less rigid. But what is intriguing, I went to a conference last week, and a paper was delivered by an architect, political scientist, and a lawyer. And for us, it's something we do when we have to be cross-disciplinary, to write something with somebody that is not a lawyer. In that case, I discovered that the lawyer was part of the panel that evaluated the PhD thesis of the other, and at the end they started working together because there was something in the research of the youngest person that was close to the law. So what I'm saying that we have tried to not always refrain from trying to talk to the other. We have probably start to evaluate if others have also something that might be interesting for lawyers. I'm not saying that we have to replace non-law with our field, but to understand the world. It is what we have to do humbly as lawyers, because we have the ability of regulating it, but we have also the commitment to understand what we study.
Well, thank you, Matteo. So it's 18:29. We have had an interesting discussion. I would like to thank all of you, and more particularly Cristina Poncibò, and of course Matteo Nicolini as the author of this book on legal geography, for being with us this afternoon. And see you next time for the next STARS webinar. Again, many thanks to all of you. Goodbye.